I'm Cody Cofer, federal criminal defense attorney. I practice in federal courts in Texas and throughout the country. Today, I'm going to talk a little bit about federal sentencing. Now, this will just be a summary and should be a starting place for your discussions with a federal criminal defense attorney about federal sentencing, the process, and how to best prepare your defense. So the judge assesses the sentence in federal cases. Other than in capital cases, that's where the government is seeking the death penalty. The judge has to decide what the sentence is going to be. And that is whether a defendant pleads guilty or they're found guilty by a jury. In federal sentencing, there are a lot of different numbers that you have to be concerned with. So starting out, you have the offense of conviction. That is going to be the charge that either the jury has found someone guilty of or that a defendant has pled guilty to. The offense of conviction is going to set the first set of numbers. That's the statutory range, the bottom and the top of the sentence that the judge can impose. Some crimes have a minimum sentence, a minimum amount of time that you'll be imprisoned. And then most have a maximum sentence, a maximum amount of time. So for instance, you may have a range of punishment that is from 5 years to 40 years. And so the judge cannot assess a sentence that is outside of that range, 5 to 40 years. That's important in deciding which charge you might plead to, or important in deciding which charges the jury might find you guilty of. Once you have the statutory range set, in the federal sentencing system, you have to be very concerned with the United States sentencing guidelines. Now, the guidelines are advisory. It's a recommended sentence that the judge should impose, assuming the case is like the standard case. To calculate the sentencing guidelines, there's a thick manual that's updated by the United States Sentencing Commission. Those guidelines are based on offense conduct and criminal history. Now, as you search around the internet or look in books, you may see a chart that has a whole lot of different numbers of months, and it has some numbers on the side of the chart and the top of the chart. That's what we're going to be using to determine what the guideline sentence is. So first, we have to look at the offense conduct. That is going to be what someone actually did, or at least what the evidence supports someone actually did for the charged offense. The offense for which the person has been found guilty or pled guilty. And so, for instance, if someone is charged with committing a crime with a gun, then you'll have a base offense level, a certain number, and then you may get additional numbers added onto that, additional levels added onto that based on the offense conduct. Now, relevant conduct is just as important as offense conduct. And this is where so many people get into disagreements and arguments with their defense counsel, because relevant conduct and how that affects the guidelines can be very difficult to accept. It seems unfair, frankly. And so your attorney needs to be talking to you about not only the charged offense, but all of the other evidence that the government may use and the court may consider in arriving at the appropriate offense level. So you may be held responsible for conduct or actions that are outside of what you pled guilty to. Or you may be held responsible for the acts of other people, co-conspirators, even if those people are not in your indictment, not charged with you. And this can be very difficult for people to accept and understand. Your lawyer needs to take the time to go through the production of evidence from the government, go through all the reasons that this might affect your offense level. Then you have your criminal history. Criminal history, generally speaking, is straightforward. There are certain areas that it can be a little trickier, a bit more complex, but essentially you're going to get a criminal history score based on certain offenses. You may add additional points. Also, criminal history can affect that statutory range that we've already talked about. There are some complexities, But by and large, criminal history is going to be objective and easy to understand based on the records in the case. So you'll have a guideline sentence, a recommended sentence, and that is going to come to you in the way of a pre-sentence report, PSR, where a person from the United States Probation Office goes through and calculates the guidelines based on information that's been provided to them by the government and maybe your defense attorney. And from there, that recommended sentence, the sides can file objections, they can file motions. And that brings us to the next part, and that is a departure. Now, you're going to hear the term departure and variance used a lot. You'll hear those used interchangeably. They're not the same. A departure is within those rules, those guidelines. The court can give a sentence that is higher or lower, can basically move the guidelines up or down or move the sentence up or down from what those guidelines are, all based on what's in that manual. Then you have a variance. A variance is where the judge assesses a sentence outside of the guidelines and does it for a reason that's not explicitly contained within the guidelines. So you go outside of those rules, outside of all of those different adjustments and enhancements. A variance is generally going to be based on factors found in United States Code 3553 of Chapter 18. And so there are a list of factors that the judge has to consider in arriving at the appropriate sentence. What's most important for you, if you're the person charged or you're a loved one of someone that's been charged, are those 3553A factors. Now, in those factors are things like just punishment, respect for the law, and other things that the judge must consider. But usually, as the defendant or a person in the defendant's life trying to be supportive, trying to be helpful, we're going to be looking at the history and characteristics of the defendant, of the person being sentenced. And your defense lawyer should file, in almost every case, a motion for downward variance or a sentencing memorandum explaining to the judge those factors and how they apply to the person being charged with the defendant. To help the judge understand the history and characteristics of a defendant for 3553A factors, defense attorney should do an investigation, should talk to people that are in the defendant's life, in their client's life, should maybe get records if there are mental health issues, if there's a history of abuse, if there's a history of poverty, if there's a history that somehow explains how the person ended up in this situation. Or, on the other end of it all, the chances that that person is going to be successful once they're released from prison or if they're placed on probation. And so the defense attorney needs to do an investigation and present all of that information to the judge for the judge to consider. Now, at the sentencing hearing, the judge is going to take into account the PSR, objections, departures, variances, anything else that is said or seen at that sentencing hearing. The sentencing hearing can be overwhelming, it can be frightening. It's usually in a giant courtroom, a lot of different people are there, things are moving fast. For the most part, sentencing advocacy has happened before that hearing, but the hearing absolutely can make a difference in the ultimate sentence that the judge assesses in the case. Now, like I said at the beginning, this is only a summary. This is only the beginning of understanding federal sentencing. I urge you, talk to a federal criminal defense attorney about the sentencing in your case or your loved one's case.